If you're a celebrity, you have new protections against paparazzi flying a low-altitude drone over your property. But if you're not a celeb, you're out of luck. Governor Brown signed the paparazzi restriction yesterday. Last week, he vetoed several drone restrictions, including one that would have required permission to fly a low-level drone over your property. He also vetoed bills outlawing drones over fires and prisons. So what's the governor's justification for saying yes to the paparazzi ban but not the others? Well, to help explain it, Stephen Miller, who's an attorney at Hanson Bridget. He advises local government, manufacturers, and users on drone policy and writes the blog hoverlaw.com. Stephen Miller, good to have you with us.
Thank you, Larry. It's a pleasure to be here.
So, can you explain why, based on the signing statements by the governor, why the paparazzi one would be signed but not the others?
Well, it's a great question. I certainly don't know that I can speak for Governor Brown, but I think if you read his veto messages, it's pretty clear that he wants to make sure that there are no unintended consequences that might stifle innovation and creativity in what is a booming technology in the drone industry. I think he's also under some pressure to avoid possible unintended consequences from those who are concerned that privacy rights might be interfered with through an increased use of drones. And I think facing those two pressures, I read his veto messages as indicating that his thought that inaction is safer than action.
I was surprised by the fire one and the prison one because, there's so many in the firefighting community who had very specific instances where drones had interfered with the ability to fight the fires using aircraft. And but that was one that he vetoed. And are there other ways of effectively dealing with private drones that people put up over crime scenes or fire scenes?
Well, so another great question, and I shared your surprise. I thought of all the measures, that was the fire safety measure was the one that might make it through. We are really in a wild west of unknowns, and I wish I could answer your question. I think local governments and public safety looking to regulate drone use are really now still in the same quandary they were in earlier in terms of when and whether they need a warrant and what their risks are should they interfere with private use. They are lacking some powers that they would otherwise have. There's very few clear rules. You can't fly a drone over a Major League Baseball stadium, an NFL stadium, or an NCAA Division I football stadium, or within 5 miles in an airport. But other than those clear rules, we're really in California are lacking really any regulatory landscape.
Stephen Miller with us. He's an attorney in private practice, advises government, manufacturers, and users on drone policy. We're at 866-893-KPCC or the AirTalk page. You want to comment on the governor's decision to sign the bill banning paparazzis from using low-flying drones over the property of celebrities, but vetoing the other limits on drones. 866-893-KPCC. Also with us is Greg McNeal, who is an associate professor of law and public policy at Pepperdine University in Malibu, and he co-founded a company that provides software for drones that can be used for safety purposes. Thank you very much, Professor McNeal, for being with us.
Thanks for having me. I'm actually joining you from the floor of the Commercial Drone Expo in Las Vegas, so this is really timely.
That's great. That's great. On location for us. Terrific. And, well, just as an aside, is this an issue that's being talked about at the convention?
Oh, my gosh. This is the bills in California were the most closely watched bills that you would see across the industry, from the firefighting ones to the interference with crime scene operations and other things, which actually the industry largely supported those ones. They opposed SB 142, which basically made a strict liability offense to fly over someone's property without permission, and they cautiously supported AB 856, which is what we're referring to as the drone paparazzi bill that the governor did in fact sign into law, and all the other bills he vetoed.
Yeah, and were you surprised by the mix of how things ended up?
A little bit. I think that with regard to the firefighting operations ones, there were existing laws that criminalize interfering with law enforcement or firefighters, and I think Governor Brown has shown that he's sensitive to sort of trends towards over-criminalization and the expansion of the California criminal code, especially because of the large prison population. So he's been a supporter of the sort of movement to not over-criminalize things.
I just have to say, as an aside, that's one of the more bizarre veto statements. How many people would possibly be prosecuted for flying a drone over a fire, particularly after one or two? And I mean, this isn't exactly going to burst prisons to the seams.
Yeah, I think with regard to the bill directly, it was a bizarre signing statement. However, taken as part of his broader philosophy, which sounds like the efforts that are presently underway to try and clean up the California criminal code, it makes sense to not add more things to it. And there are also some measures in place to try and prevent people from flying over fires. So in the introduction and by way of disclaimer, we mentioned my company AirMap. AirMap provides live notifications to drone operators when they're near forest fires and wildfires. And the FAA has been enforcing against people under those civil authorities and the existing California authorities. And so if you start to get into the weeds, which it sounds like you really did, that one makes sense. SB 142, his veto message on the trespass bill was that, before we go down this path, let's be a little bit more narrow. And I think we have to read this in the context that all of the major drone manufacturers in the United States have an office in California or are headquartered in California. And if California wants to be a state that supports innovation, the governor's in a position where he has to carefully balance both innovation and protection of citizens' interests.
Yeah. Well, I mean, it's ironic that had it been criminalized to fly over prisoned or fired, I would think your software would have been made even more valuable because the stakes would have been higher, right?
It's funny. That was a first thought that people sort of present to us. But what we're finding is that the industry is so afraid of regulation that it's running very quickly to self-regulate, to be able to say, look at the stuff we already have. We can create solutions with technology faster than the laws can keep up. And so I actually think the little bit of time that Governor Brown has provided here and the sort of the scare that was put into the industry by seeing the legislation has done more to foster innovative ways of enhancing safety and privacy than any law could have done. The question will be whether or not the industry actually acts on that scare, or do they think they dodged a bullet?
We're talking with Pepperdine Associate Professor Law and Public Policy Greg McNeal, Stephen Miller, also an attorney based in San Francisco. Both these gentlemen experts on the emerging law regarding drones. I guess as expert as you can be, because it really is a truly emerging field. You have questions or comments, 866-893-KPCC. Brian in Palmdale, welcome.
Hi, how you doing?
Good.
My thought was that we could have all drone manufacturers hardwire each drone to broadcast their position. That way, any aircraft in the area would know where they're at and could avoid them.
Greg McNeal, is that feasible?
That is not feasible today for the vast majority of drones, because the vast majority of drones don't have onboard cellular connectivity. I would say that is, and most in the industry think that that's possible in 2016 or 2017 as the technology miniaturizes. There will be some drones that cost a couple $100s that will never have that type of connectivity to the internet through cellular. And then the bigger technologies, like something known as ADS-B, which is the way that manned aircraft communicate with other manned aircraft, we're still a little farther away on being able to put that technology in. But everyone in the industry is thinking about that as a necessary solution to not only the potential safety problems of colliding with manned aircraft, but also the accountability problems of knowing which aircraft is operating where in the airspace around people and in neighborhoods.
Gentlemen, thank you. It's been a pleasure talking with you both. Greg McNeal, Pepperdine University, and Stephen Miller of the law firm Hanson Bridget. It's Air Talk on KPCC. Coming up, our special hour from UC Irvine, the program that we did last night. We bring it for you coming up in the noon hour, including some web-only Air Talk overtime with audience questions to follow.